Hi everyone, and thanks for joining me today for this pre-recorded lecture. My name is Carolyn Sawyers. I've been working in copyright administration on the music publishing side for about 30 years. I joined BMG Rights Management in October 2018. Prior to that, I worked at Universal Music Publishing for 23 years. My very first music publishing job in my early 20s was at Bug Music, and since BMG now owns Bug Music, I've come full circle. This is the first of 3 courses I'll be presenting on Copyright 101. Please note that this first course is extremely rudimentary, so if you're familiar with the basic concept of copyright, you might want to wait until course 2 and 3, where we'll be covering different types of agreements, licensing, U.S. reversionary rights, etc. But for this first course, we'll review the history and purpose of copyright, the 6 exclusive rights, categories of copyrights, and we'll explain the difference between song copyrights and recorded copyrights. So what exactly is copyright? What does it mean to copyright a work? Copyright is a form of protection for original works of authorship that are fixed in a tangible medium of expression. Now, what is considered an original copyright? Well, according to the U.S. Copyright Office, works are original when they are independently created by a human author and have a minimal degree of creativity. Independent creation simply means that you create it yourself without copying. But what does it mean to fix something into a tangible medium? Well, as soon as a book is written, a song is recorded or written out onto sheet music, a painting is completed, a film is finished, etc., that's a copyright. A copyright exists. Here's an example of some tangible mediums of expression, books and records. So we know what copyright is, but what is the purpose? Why does it exist? It encourages the progress of useful arts by protecting the rights of creators. The United States Constitution, Article 1, Section 8 states, Congress shall have power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Here's a painting of the Library of Congress in Washington, D.C. Now let's talk about what copyright is not. Things that can't be copyrighted are titles, names, short phrases or slogans, ideas, concepts, inventions. Those things might be able to fall under the trademark laws or patents, which are other types of intellectual property, but that's a different category than copyright intellectual property. Copyright are creative works that are fixed in a tangible medium of expression, as we discussed before, like films, music, books, paintings, etc. Inventions, slogans, trademarks, those do not fall under copyright. That would be under potentially patents or trademarks. What is the duration of copyright? How long does it last? Current protection of copyright in the U.S. for works created after January 1st, 1978 is life of the author plus 70 years. This excludes works for hire, which we'll touch upon later. And copyright duration varies throughout the world. Different territories have different lengths of copyright duration. For this class, we'll be focusing on U.S. copyright law only. How did we get here? Let's review a brief history of copyright in the U.S. The basis for U.S. copyright law actually originated in Britain with the 1710 Statute of Anne. Prior to that, there were some privileges and monopolies granted to private parties, but the Statute of Anne was the first copyright statute to be regulated by the government and the courts. The copyright duration was 14 years plus a 14-year renewal term. It wasn't very long, but it was a start. The first major copyright act in the United States was the 1909 Copyright Act, signed into law by Theodore Roosevelt, which granted 28 years plus a 28-year renewal term equaling 56 years. But it was problematic because any recording or sheet music without a proper copyright notice affixed to it could fall into public domain. The next major reform wouldn't happen until 1976 with the 1976 Copyright Act. It included sweeping changes, including getting rid of that very problematic statute in the previous Copyright Act, which stated that anything without a proper copyright notice could fall into public domain. It got rid of that, replaced that 1909 Copyright Act completely, and it extended the copyright duration to life of author plus 50 years. It also stated that once an original work was fixed into a tangible medium, like we talked about at the beginning of the presentation, that the copyright then existed. It didn't depend on the copyright notice or anything like that. Once it just had to be fixed into a tangible medium. It also established the 6 exclusive rights, which we'll discuss in a few slides. And it allowed writers and artists to terminate their works 35 years after publication. And we'll be discussing statutory reversions in Class 3. The next and most recent Copyright Term Extension Act was the Sonny Bono Act, named, of course, after Sonny Bono from Sonny and Cher. It extended copyright duration to life of author plus 70 years, and that's currently what we have today. Sonny Bono was a huge supporter of copyright protection, and after his passing, this act was named after him. And proponents of the act at the time included major entertainment players such as Disney, Universal, Time Warner, and Viacom. People who were against the act referred to it derisively as the Mickey Mouse Act, because Disney was such a huge supporter. Some early Mickey Mouse cartoons were about to fall under public domain, and Disney really got behind this extension so that it could lengthen the copyright duration for some of its most famous cartoons. The categories of copyrightable works are literary, musical works and accompanying lyrics, dramatic works, pantomimes and choreographic works, pictorial, graphic, and sculptural works, motion pictures and other audiovisual works, sound recordings, and architectural works. What we'll mostly be focusing on in these courses is 2, musical works and accompanying lyrics, which is the song side of copyright. It's different from the sound recording side of copyright, which I'll explain in a few slides. So the 6 exclusive rights of a copyright owner are the right to make copies, and since we're talking about music, that would mean CDs or albums, but it could also mean digital copies as well. The right to distribute a work, meaning making it available to the public, and in the case of music, that would be streaming or selling the physical copies in stores. Right to create derivative works. An example of this would be a new lyric version of an existing work, or if an existing work is sampled into a new song, that new song would be considered a derivative work of the original. The right to publicly perform a work, the right to publicly display a work, and the right to publicly perform a sound recording through digital transmission. So what is the difference between song copyrights and sound recordings, which are also known as the master copyrights? And I've actually had friends tell me, well, there isn't any difference between the song and the recording. The song is the recording. What do you mean they're 2 different rights? And I'll explain why that is. They are actually 2 separate copyrights. The song is the music, or words in music if there are lyrics, and the recording, also known as the master, is the recording. There can only be 1 song copyright, but there could be many different recording copyrights of that 1 song, and I'll give you an example in the next slide. And here's an example. The Beatles song, Meaning the Words and Music, Yesterday by John Lennon and Paul McCartney, constitutes 1 copyright, the song or publishing right. That is 1 copyright. But their recording of that song constitutes a different copyright, which would be the recorded or master rights. The 2 separate rights here. And here's just a few examples of the many different recordings of the Beatles Yesterday, from Marvin Gaye, Ray Charles, Frank Sinatra, and each of those recordings is its own master copyright. It's its own right, but the song is just 1. That's the one copyright by John Lennon and Paul McCartney. Now, most writers and artists, when they get to a certain level in their career, realize they don't want to spend all of their time keeping track of all their copyrights and their income and all of their royalty streams. And they sign into agreements with companies like BMG Rights Management that will handle that for them on both the publishing and the recorded side. But typically, songs are administered, owned, or co-owned by publishing companies. And as far as the recordings, what would be administered on the master side, those are typically owned and distributed by record companies. Also, like BMG Rights Management, we handle the two sides of publishing and masters. We have two different factions that handle those. So now that you understand the very basic concept of copyright, in the next two classes, we'll be focusing on the songs music publishing side and discussing various types of agreements and licensing. We'll also be covering copyright terminations, fair use, and the Music Modernization Act. Thank you for listening to this pre-recorded presentation today. If you have any questions, please go ahead and contact me at either my work address or my personal email. Thank you so much, and I'll see you in the next class.